Rain had been falling off Black Mountain since before dawn. Nora Vasquez had driven 4 hours from Lexington and had 5 days left on a deadline that allowed for nothing. In the passenger seat, Coda lifted her head toward the tree line, the attention of a dog that has already decided. At the end of the gravel track, in a house built in 1947 on land held since 1923, an elderly couple was about to lose everything, and a court had told them twice that the law agreed. What that Marine and her K-9 found in the barn would give the law something it had not yet been asked to look at. If this is your first time here, stay with me through this one. Subscribe, because this is exactly the kind of story this channel exists to tell. Nora Vasquez had been a judge advocate in the United States Marine Corps for 6 years, which meant that the law had been her weapon and her shelter and her daily argument with the distance between what law said and what law did. She was from San Antonio, had gone to law school at UT on an ROTC scholarship, had served at Camp Lejeune and Okinawa in the particular role of an attorney whose client was the institution, and whose job was to represent it faithfully, and whose private education, conducted over 6 years of practice, had been in the many ways that faithful representation of an institution was not the same thing as justice. She had left when she was ready. She had taken her bar license and a dog and a specific understanding of how property fraud worked and how it didn't get prosecuted, and she had gone looking for the places where that gap was widest. Her grandmother Consuelo had owned a house in San Antonio for 41 years, a small house on Brazos Street in the neighborhood where Nora had learned to ride a bike, and where the neighbors knew each other's names, and where the bakery on the corner had made the same pan dulce since 1978. In 2014, while Nora was in her second deployment, a reverse mortgage company had worked Consuelo through a process that was technically legal and practically designed to be impossible to reverse. A process that required a 78-year-old woman to understand, alone, without an attorney. The financial instrument being placed around the house she had owned outright since 1983. By the time Nora came home, the appeal window had closed. Consuelo spent her last 4 years in a back room at Nora's aunt's apartment, surrounded by the things she had been allowed to take, which were not the walls or the light from the kitchen window or the 41 years that lived in the grain of the floors. She died in 2019 and was buried from a church that was not hers. Nora had never been able to fix this. She had been able to learn it well enough to fix it for other people, which was a different thing, and which she had decided was sufficient, and which on most days she believed. Coda had come to her through a veterans transition program in Louisville. She was liver and white, low-slung, a Springer cross with an expression of permanent and genuine interest in whatever was immediately in front of her. She had been trained first as a courthouse therapy dog, the kind of dog that sits with children giving testimony, or with elderly witnesses who need something steady to look at, before the program had repaired her with Nora, which had turned out to be the correct decision for reasons neither of them had anticipated. Coda moved quietly and was drawn to paper, not in a destructive way, in the way that certain dogs are drawn to the smell of age and ink and the particular objects that human beings treat with the care reserved for things that matter. She had twice led Nora to documents that were relevant before Nora knew they were in the room. Roy Alderman had been 19 years old when he enlisted in the Navy in 1962, after the Korean War, before Vietnam, in the flat peacetime interval when service was simply service, without the frame of crisis that makes it legible to strangers. He had served 3 years on the US Leyte Gulf, had done his work with the precision of a young man who understood that precision was the thing the Navy asked of you, and that what it gave you in return was a way of being in the world that lasted longer than the service did. He had come home to Harlan County in 1965, had married Bet Colson at Clover Fork Baptist Church on a Saturday in June, and had begun the life that the house made possible, working the mines for 16 years, then switching to electrical work when his back gave out, then retiring at 62 into the particular occupation of a man who knows how to fix everything on a piece of property, and is never without something that needs fixing. The house had been built by his father, Leonard Alderman, in 1947 on land the family had held since 1923, when Roy's grandfather had received a federal land grant for a parcel in the Clover Fork Hollow that was recorded in the Harlan County deed books and that had been paying property taxes without interruption since 1951. Roy knew this the way he knew the electrical system he had rewired in 1989 and the foundation he had repointed in 2003, not as history but as architecture, as the thing the whole weight of the present rested on. Bet Alderman had taught piano for 44 years out of the sunroom on the south side of the house. 312 students, she could tell you. Because she had kept a ledger. Children from Clover Fork and Loyal and Cumberland who had grown into adults and who remembered, some of them, the specific texture of the afternoon light in that sunroom, and the sound of the upright piano, and the way Bet Alderman had the patience to stay with a difficult passage until the student found it rather than giving them a simpler one. She had stopped teaching 4 years ago when her hands had begun to trouble her, but the piano was still there and she still played it in the mornings. And the sunroom was still where it had always been, which was the thing that was now in question. The moment the Aldermans had begun to understand the full weight of what they were losing had not been the day the quitclaim transfer was recorded. It had been a Tuesday in October, 2 years ago, when Bet had sat down at the piano in the morning as she always did, and had looked at the sunroom around her, the particular light coming through the south-facing windows, the potted fern on the sill, the mark on the doorframe where she had measured Roy Jr.'s height every birthday from 1967 to 1979, and had understood that she might be playing in someone else's room. She had kept playing. She had not told Roy what she was thinking, because Roy was already carrying enough, and because naming it would have made it real in a way she was not ready for. She had simply played the piece through to the end, and then played it again, and then gotten up and made breakfast, because this was what you did when the thing you were afraid of was still a possibility rather than a fact. You behaved as though it were not going to happen, and you held on to what you had. Dennis Vance had come to the house in the spring of 2019 with a form and a smile, and the practiced vocabulary of a man who had done this before. A corrective deed, he explained. A minor administrative fix. The original 1947 legal description had a survey discrepancy that the county recorder had flagged, and that required a simple remedy before it caused any problems. He was patient. He was unhurried. He used the word routine 4 times. Roy had asked questions, and Vance had answered them in the register of a man explaining something obvious to someone who is perhaps not quite following, which was a register Roy recognized, and which had the effect it was designed to have. Roy had signed. Bet had signed. The form went back to Vance, and what came out of the county recorder's office 6 weeks later was not a corrected deed. It was a quitclaim transfer of the Alderman property to Stonegate Holdings, LLC. They had been fighting it for 2 years. The circuit court had ruled against them on summary judgment 6 weeks ago. Their court-appointed attorney, a young man doing his best with an overfull docket, had missed a filing deadline and had not attached the 1923 land grant to the appeal brief. The judge, not a corrupt man, a tired man, a man with 40 cases on his active docket, had ruled on the record in front of him, which did not contain the document that would have changed the ruling. The appeal window had been open for 9 of its 14 days when Rolland Bryce at the Kentucky Veterans Legal Aid Network in Pikeville had called Nora's cell phone on a Tuesday evening and told her that an elderly, couple in Harlan County had 5 days to save a house their family had held for 100 years. She had been in the car by 7 the next morning. Nora had read the summary judgment ruling an arrest stop outside Richmond. She had read the corrective deed filing. She had read the court-appointed attorney's brief, which was competent and incomplete in the specific way that briefs are incomplete when the attorney does not have the foundational document and does not know it exists. The 1923 land grant, if it existed, if it said what Roy had told her it said, if it was in the condition Roy believed it was in, was not just evidence. It was the case. A federal land grant superseded a county deed irregularity. Vance's corrective filing could not touch land whose title chain ran to a federal instrument. The circuit court had ruled on a record that was missing its foundation. That was not the court's fault. It was a fact that could be corrected in 5 days if the document was real and if it was findable. Roy had said, "The barn." Coda had gone ahead of her. She found the workbench in the back of the barn without being directed, moving along the wall with the low, methodical attention of a dog following something Nora couldn't smell. She stopped at the workbench. She sat down. She did not move. Under the workbench was a metal strongbox, the kind sold in hardware stores in the 1970s, with a combination lock that Roy dialed open without hesitating, because some numbers a man keeps in a different part of memory than the names of things he has begun to forget. Inside the strongbox was a stack of documents in a brown paper accordion folder. Nora lifted the folder out and opened it on the workbench, and the smell that came off it was the smell of old paper and oil and time. The particular smell of documents that had been kept somewhere a person considers safe. The 1923 land grant was on top. Parchment weight paper, handwritten in a surveyor's precise copperplate, signed by a federal land office agent named Carver Willis, and stamped with a seal that was still legible after 101 years. The legal description was exact. The parcel boundaries matched the alderman property. The grantor was the United States government. The grantee was Samuel Roy Alderman, Roy's grandfather, in fee simple absolute. Below it, in chronological order going back to 1951, were 72 years of consecutive property tax receipts. Every year. Every payment. The paper from the early years was thin and soft at the folds, but the ink was legible and the stamps were clear. 72 years of a family saying, every year, this land is ours and we are paying for the right to hold it, and we are not hiding. Nora stood at the workbench for a moment, with the land grant in her hands. She thought about a house on Brazos Street in San Antonio. She thought about what it would have meant for someone to drive 4 hours and open a strongbox. She did not say this. She put the land grant back in the folder and picked up her phone. Have you ever known a family like the Aldermans? People who kept every receipt, every document, every record, who did everything right and still found themselves standing in front of a court that hadn't been asked to look at the right thing? If that family is yours, or if you know them, tell me about them in the comments. They deserve to be remembered. She called Hal Bryce in Pikeville, who had been waiting for her call. She told him what was in the strongbox, and he told her what he needed, and she told him she would have it to him by morning. She called the Kentucky Court of Appeals clerk's office and confirmed the filing deadline, and asked about the emergency motion procedure for newly discovered evidence, and wrote down 3 names and 2 fax numbers that she did not intend to need, but intended to have. She called a forensic document examiner in Lexington she had worked with twice before, and arranged for an authentication declaration on the land grant to be completed by the following afternoon. Because authenticity was not in question and would not be in question, but a court needed a record, and the record needed to be complete, and completeness was the thing Vance had been counting on not existing. Then, she found the photograph. It was in the accordion folder between the 1963 and 1964 tax receipts. A black and white photograph, 3 inches by 5, of 2 young men in Navy uniforms standing on the deck of a ship with a mountain of water behind them. On the back, in ballpoint, Garrett and me. Gulf of Tonkin, October 63. Roy had written it himself, in the handwriting of a 21-year-old. She brought it inside and set it on the kitchen table. Roy picked it up and held it for a moment with the particular careful attention of a man holding something he has not looked at in a long time. He said the name without being asked. Garrett Shin. He said it the way you say the name of someone you served with, which is different from the way you say anyone else's name, quieter and more final, and with a small silence after it that is not grief exactly, but is adjacent to it. Nora asked if Roy knew what had happened to Garrett. Roy said Garrett had passed in 2008. Had a son, he thought. In Frankfurt, maybe. Nora looked up the name on her phone. Daniel Shin. Kentucky Attorney General's Office, Property Fraud Unit, Frankfurt. She found his direct line in the AG's public directory in 4 minutes. Because public servants list their contact information and the work requires knowing where to look. If you were sitting at that kitchen table in Harlan County with 5 days left and a document in your hand and a phone number on your screen, would you have made that call? Type yes or no below. I read every one. She made the call that evening. Daniel Shin had his father's voice, she thought, the way some qualities travel through. He had been in the property fraud unit for 6 years. He knew Stonegate Holdings. He knew Dennis Vance. He said the name in the specific tone of a man who has a file open on his desk and has been waiting for something to make the file move. She told him about the aldermans. She told him about the corrective deed. She told him there were 3 other Harlan County properties she had found in the recorder's index with the same pattern. Elderly owners. Corrective deed filings within the same 18-month window, all recorded through Vance's office. Daniel Shin was quiet for a moment, and then he said, "Can you give me the parcel numbers?" And she read them from the list she had already made because she had already known, from the moment she read the first corrective deed, that 1 transaction was a mistake, and 4 was a pattern, and a pattern was a case. They filed the appeal with 4 hours to spare. The emergency motion attached the authenticated 1923 land grant, a sworn affidavit from Roy Alderman documenting the misrepresentation, a forensic declaration confirming the document's authenticity, and the absence of any survey discrepancy in the original 1947 deed, and a supplemental brief prepared by Hal Bryce's clinic detailing the federal land grant's superseding effect on the county deed chain. Daniel Shin's office filed a parallel fraud referral with the circuit court the same afternoon. It was a Friday. The clerk's timestamp read 4:47 p.m. Dennis Vance had heard through the county recorder's office that someone was in Harlan asking questions about the corrective deed filings, and he had come to the courthouse that Friday afternoon for reasons he would have described as routine, and which were not routine. He was standing in the corridor outside the circuit clerk's window when Nora came through the courthouse door with Roy at her side and Hal Bryce's supplemental brief under her arm, and Coda on a short lead at her left. Vance saw Roy first. Something in his posture shifted. The practiced assurance of a man who has won these proceedings before and who has arrived to confirm that the outcome is what he arranged it to be. Then he saw the woman with her. Then he saw the brief in her hand, which was thick enough to mean something he had not anticipated. Coda stopped walking. She did not make a sound. She positioned herself between Nora and Vance with the absolute stillness of a dog that has spent years sitting with people who were afraid and has learned to recognize before the people themselves recognize it, when the source of that fear is standing in the room. The low attention she gave Vance was not aggression. It was something more considered than aggression. It was the attention of an animal that has already assessed the situation and is waiting to see whether it resolves itself. Roy Alderman looked at Dennis Vance across the corridor of the Harlan County Courthouse in the particular way that a man of 79 looks at a man who has spent 2 years trying to take from him the thing his father built. He looked at him for a long moment, and then he looked at Nora, and he said, quietly, the thing he had been trying to say to someone for 2 years. I just need somebody to look at it like it matters. He walked to the clerk's window and handed Nora the sworn affidavit, the one he had written himself, and the same careful hand he had used to label every tax receipt since 1951. And he looked at Vance once more while Nora slid the filing package through the window. Nora said, without raising her voice and without looking at Vance, because she was looking at the clerk's timestamp, the 1923 federal land grant supersedes the county deed chain. We've attached the authentication declaration. The fraud referral has been filed with the AG's property unit as of this afternoon. She turned then, briefly, to Vance. You've seen Mr. Alderman's affidavit. If you'd like to read the land grant, it's in the attachment. Vance said nothing. There was nothing to say that would help him. Coda watched him from beside Roy until the three of them walked back through the courthouse door, and then she shook herself once. The small, complete shake of a dog releasing held attention and followed them into the November cold. Dennis Vance was in his office on Main Street in Harlan when the formal referral arrived that evening. He had a daughter's tuition bill on his desk. He had a coffee that had gone cold. He read the referral once and then read it again, and what crossed his face in the interval between the two readings was the expression of a man whose justification has been taken out from under him and who has not yet found a new place to stand. He called his attorney in Lexington. He was on hold for 11 minutes. On the following Monday, the Kentucky Court of Appeals issued a stay of the summary judgment pending the appeal hearing. The alderman's deed transfer to Stonegate Holdings was suspended. The house on Clover Fork Hollow was theirs to live in while the record was corrected, which the record was going to be corrected, because the land grant said so and had been saying so since 1923 and had simply been waiting in a metal box under a workbench for someone to bring it into a room where it could be heard. The land had been speaking the whole time. No one had asked it to testify. The Attorney General's investigation into Stonegate Holdings expanded to include all 4 Harlan County properties and 4 additional transactions in Bell and Leslie counties identified through the recorder's pattern. The 2 families still living as tenants in their own land were formally notified of the investigation. What happened to Dennis Vance is a matter of record in the Kentucky Bar Association's disciplinary proceedings. What happened to the Aldermans is that they stayed. Nora came back to Harlan the following spring, not for a court date, just to come back. The dogwood was out along the creek road, and the hollow looked the way hollows in eastern Kentucky look in April, which is like something that has been holding its breath all winter and has just remembered it doesn't have to. Bet was in the sunroom when Nora arrived. She was playing the piano, a slow piece Nora didn't recognize, with the particular quality of concentration that means a person is not performing for an audience, but is doing something they do for themselves and have been doing for a long time. Roy was in the barn. He had started a new repair, the back door frame, which had been swelling in the cold and needed to be reset. He was working slowly, and with the methodical attention of a man who knows that the work is not going anywhere, and neither is he, and that the space between those 2 facts is the place where a person who knows what they have is most fully alive. Coda lay in the open barn door in the April sun, with her nose pointed at the tree line and her eyes at half-mast. which was her expression of absolute contentment. And Roy had given her a biscuit he'd found in his jacket pocket, and she had taken it with the grave and courteous manner she brought to all transactions. Nora sat on the workbench and drank the coffee Roy had brought out without being asked, and she did not say everything she was thinking, because the situation did not require it to be said. Which is the particular quality of moments when a thing that was broken has been made right, and the rightness is in the room and does not need announcing. There are people in every county in this country who have done everything right, who kept the receipts and the records and the original documents and never missed a tax payment, and who found themselves in a courtroom facing a law that had not been shown the right piece of paper. The paper existed. It always exists. What it needs is someone who knows how to find it and knows what it means, and is willing to drive 4 hours on a Tuesday and look under a workbench. She simply didn't turn the car around. This story is for every family that kept the records because they understood, without being told, that records are the way the past defends the present. And for anyone who has stood in a barn holding a piece of paper that should have been enough and wasn't, and held on anyway. Is there a Roy and Bet in your life? A family member, a neighbor, someone you know who is fighting for something that should already be theirs? Tell me about them in the comments. Let's fill this section with the names of people who held on. Every story on this channel is about choosing not to look away. If that means something to you, subscribe, so you're here for the next one. Which moment in this story stayed with you? I'll see you in the comments.